The Free State High Court in Bloemfontein is hearing Moroadi Cholota's urgent application today to have her arrest declared unlawful and unconstitutional. The former personal assistant to the then Free State Premier, Ace Magashule, argues that the 255 million rand asbestos corruption and fraud charges against her emanate from her refusal to comply with the state demands for specific testimony on the case. The 37-year-old is asking the court to deem the charges against her invalid and to withdraw them. Cholota is out on 2,500 rand bail following her extradition from the USA. All right, let's bring in a legal analyst, Elton Hart now. He joins us via video link just to unpack Cholota's bid to declare her arrest unlawful. Thank you so much, Elton, for your time. Are there any grounds to have her arrest declared unlawful and unconstitutional?
No, I think with our constitution, there's always that room for a person to say that I've been unlawfully and unconstitutionally arrested or charged with any offense whatsoever. The other thing that one has to look at is the merit in bringing such an application. And obviously, hearing the state's argument and stuff like that, and I know that a pre-trial will happen on the 11th of September, because now to come to court on an urgent basis, I think she could have left it and wait for the pre-trial and then set the application down to say, on that day, I want to still ventilate this issue because I feel that my extradition to South Africa and me being charged for these corruption, fraud, money laundering charges should not stand against me for X, Y, and Z, and then have an application run that way. So for me, I think to bring it on an urgent basis, I think the urgency will fall away. It's not urgent because she's on bail unless there's something miraculously happening that says that it's urgent, but I don't see urgency in her application. But she has a constitutional right to go this way and actually pursue this avenue that's at her disposal.
Just on that interdict part that she wants, I mean, just given the laundry list of charges that she is facing, what does it actually entail that she now wants to interdict her arrest?
No, the entire thing, she wants the charges against her to be withdrawn. So she wants actually to be squeaky clean, to say that there's nothing pending against me and I can then carry on with my life. I'm not involved in this trial. And I think that for the court to do is against public policy because there's public interest. Remember, this stems from the asbestos projects where a lot of people's lives was affected because there was tender irregularities and fraud associated with that project. And they now charge her to say that she had knowledge or she was somehow a co-conspirator, or she helped this fraud and corruption happening under the watch of the former premier. So for her now to come and say, okay, I want the court to now interdict the state from prosecuting me, then it means that every prisoner in prison can now come to a court and say, I don't want the prosecuting authority to prosecute me. Stop the charges against me. And I don't think that is in the public interest and in line with the constitution, because then what will the role of the NPA then be in curbing crime in our country?
And I mean, just looking at some of the things that her lawyers keep harping on in, her plight, saying that, the charges against her actually emanate from the refusal to actually comply with the state demands for specific testimony on the case.
But for me, normally the state has that option, and it's part of the arsenal in the state's toolbox. They have what we call Section 204 of the Criminal Procedure Act. The state can offer you a deal to say, listen, if you testify honestly and frankly, even going as far as incriminating yourself where a crime was committed, because we want to actually get all the important role players in this, then the state has that option of offering you that deal. And if you refuse to take that deal, then the state has the prerogative to say, now listen, we offered you the 204 deal, you don't want to take it, so we'll just prosecute you with the others, and whatever evidence we have, we'll make do with what we have, but we're offering you this deal because you are not really, if one can say, the main peanut in the pack that we're looking for. We're looking for the real main guns in that facilitated this crime. We want to get to them to actually curb crime. And if you don't take it, then it's your choice, and then we just charge you. So you can't tell the state who they should charge and who they should not charge. If they've got evidence, they charge you.
And not forgetting, of course, that Cholota also gave, evidence in the Zondo Commission, which was instrumental at that particular time, and also the reason why she was then, said to be a witness in this particular case. To what extent does her testimony at that time, will it count in terms of the charges she's now facing?
Now they can use that testimony. Remember that testimony that people gave at the Zondo Commission, it was just evidence that was given, but that evidence still needs to be subjected to various things to see, does it pass the test of admissibility? And also it will be subjected further to cross-examination. So what she gave at the Zondo Commission was like one-sided affair, like she was making a lot of allegations, and for it to stand as evidence in court, it needs to pass the admissibility test, and it needs to be subjected to cross-examination. So if she's now saying, she said something there, and she's now retracting, she's got that right to retract and not cooperate. But the moment you don't cooperate with law enforcement agencies, you cannot now interdict them to stop them from charging you. And they can charge you now for all sorts of crimes as long as the evidence that they want to bring against you supports whatever they're putting against you as a charge.
I would imagine the state, of course, is going to oppose this. I mean, when you look at some of the things that she said in her affidavit, in as far as how the police as well as FBI agents arrived at her apartment in the US, and how their line of questioning was starkly different to the line of questioning that she was subjected to during the Zondo Commission.
Now, if one looks at what happened at the Zondo Commission, and I have had little bit sight of her affidavit pertaining to what she says, the circumstances under which she was arrested and then kept in custody. And she said she was willing to cooperate, like sort of, but when they started now putting stuff in the statements and stuff that she had to admit to certain things that she does not bear knowledge to, that's when she felt like, okay, this is the turning point for me. I cannot testify to something or give evidence just so that they can leave me alone in the USA. I cannot do that because this has never happened. It never happened. And it's contrary to what I said at the Zondo Commission. And I think that is what she is sort of looking from the bail application and also what was averred today. That's the turning point where she decided, listen, then I'm not going to then give any further statements because it seems like the law enforcement agencies with the FBI is trying to actually sort of have, if one use plain language, turn my words and add a little bit of a tail to what I actually said at the Zondo Commission to incriminate the 16 other accused in the asbestos matter.
Elton, thank you so much for your time. Of course, Elton Hart is a legal expert commenting there around this matter. The Free State High Court in Bloemfontein currently hearing Moroadi Cholota's urgent application today to have arrest declared unlawful and unconstitutional. In fact, I am hearing that the possibilities that the case has now been dismissed. The Free State High Court has dismissed the urgent application of Moroadi Cholota with costs. Judge Marina Opperman stated that her reasons will follow in due course. Unfortunately, came just as we wrapped our interview there with Elton Hart. But of course, I think he had also predicted that the urgency part will definitely fall away. But as you have it, those are developments then from this particular court case, Moroadi Cholota. We will hear from Judge Opperman in terms of her reasons then to dismiss that particular case.